All right, it is time to go live. This is attorney Matthew Newsom with Surge Business Law, and it is once again time for Ask Me Anything. This is December 15th. We have a bunch of great questions for you. Just a reminder for those watching live or the recording at a later time, please hit the like button or subscribe so that you make sure to see the future events. Also, too, I would like to remind you that you should talk to a lawyer about your specific questions. I would love to learn that you are using the information that I create to help your business be more successful. But all of this information is general information. You should ask a lawyer about your specific details. And if you're around me, you should call me because I would love to help you. Let's start by digging into our questions. First question, this came up, I put it on the list, but it came up during one of my client meetings this week. Should I copyright my source code? And this is targeted at computer programmers, people who write software for a living. And the question is, first of all, can you copyright source code? And the answer is yes. As soon as you create it, it is no different than a painting or a poem. You have the right to copyright it. And in fact, you receive a copyright to it. But should you register the copyright? And the answer is usually not. And there's various reasons for that, but one of them is it's just difficult to do because your source code is commonly changing. I worked on the software development team, the open source software development team at Google, and I put in an example of what they tell the programmers at Google who are contributing to open source software to use. And that is you just put a copyright statement right there in the top of your source code so that people know who wrote it and who owns the copyright. So this is an excellent document. The link is there in the screen. So go check that out if you would like to learn more about it. But yes, you should and do get a copyright, but no, you should not register your copyright. Next question from Samuel. Samuel is a serial question asker, and I love it. He asks great questions. Is there an agreement permitting many people to collaborate and create a product that they distribute together? And I edited that question down a little bit. Samuel is a software developer, and he works he enjoys participating in a team of game developers, and they, I think, are working on something collaboratively, and he wants to make sure that they do it right. And I think I might have scared Samuel just a little bit way back when I answered one of his previous questions about partnerships. And it's easy to be surprised or maybe spooked a little bit by partnerships because accidental partnerships can be quite dangerous. An accidental partnership is an unlimited liability situation where the partners each individually, separately, can be responsible for all of the debts and problems of the business. And you can and should be quite scared to take on the liability of your partners without some kind of agreement. However, that does not mean that partnerships are necessarily bad. It's just the accidental ones that are bad. And so what I want you to think about instead is putting your agreement to collaborate or partner with each other into writing. And you can do this in a couple different ways. In the US, we have partnership agreements, which typically do not need to be registered unless you want to get limited liability. But partnership agreements simply put into words the things that you guys describe. And so it is a contract. I agree that I'm going to do this or I'm not going to do that. If we make money, this is what we're going to do. And so a partnership agreement is a good way to go. However, partnerships do not get limited liability protection unless they are registered. And if you're going to go through the hoops of registering it, you might prefer to instead use a little bit more of a modern solution, such as a limited liability company. Limited liability companies allow for many people to collaborate with each other. Now, if you've done a little research on the internet, you might have found that there are certain limits, depending on how you want to be taxed, on who can be a participant in a limited liability company. First of all, I want to just say that if you're not worried about the tax situation, there's really no limit. Partners can be U.S. citizens, Canadian citizens, other foreigners. It can be businesses, can be owners of a LLC. So all of that is fine. So I would suggest an LLC if you are in U.S. or Canada. Some other countries have similar things that are not called LLCs. but they allow for a high degree of flexibility. And it allows you to either choose to make money or not make money. It's open to you guys to decide. So if you want to have an agreement that allows people to collaborate and create a product together and distribute it for or without profit, then creating a formal entity like a limited liability company is the way to go. Now, if you think you might want investors who would bring cash, you might actually want to go a step further and create a corporation. And in that case, first of all, I've already talked about this in previous videos, and so I'm going to refer you back to the channel to look at the AMA question for whether or not you should be an LLC or corporation. But corporations are friendly to investors. And so if that's your plan, go for the corporation. Sean asked this question: how to avoid giving away ownership of intellectual property while promoting yourself or getting a prototype or product made. And this does happen because oftentimes, in order to take your idea to the world, you're going to need help. It's very, very rare that one creator has enough knowledge to market their product and get buyers and things like that. They usually have to bring in helpers. And this is an opportunity to do that thing that I said before, don't do, and that is to create an accidental partnership. When two people shake hands metaphorically or actually with the intent to profit, then they've created a partnership and they might not have meant to. And an accidental partnership in that case causes unlimited liability, which is not good. And so what we want to have is we want to have a clear contract saying this is what's going to happen. And so if you are doing an agreement to produce or publish a product. I actually answered that one in a previous AMA as well. In fact, it was Samuel, the person who asked the previous question, who asked about it. And so an agreement, and I did go through in the video, to tell you all the different things that are going to be in that agreement. But it basically sets rights. You have the right to this. You have the right to that. You do not have the right for this. And also, too, something very important in that agreement is that it basically says that we're not making a partnership. One of the things that I know some people care about, and I happen to know that Sean would care about this, is that you can also specify what causes that partnership, that arrangement to end. And so it is possible that you might want that to be a perpetual thing. And so, for example, let's just say that you've created a textbook and all you want to do is write and teach. You don't want to worry about that. Ideally, get a check in the mail each month. Great, you can do that. And it's common to work with a book publisher that gives them something like a perpetual agreement to act on your behalf. And depending on when you enter this agreement, it might be limited to, a couple dozen years, and then it has to be renewed. But the way that you avoid giving away ownership of intellectual property is to have a contract. And so that could be a publishing agreement, or it could be some other kind of agreement, a marketing agreement or manufacturing agreement. There's different terms for it. This is a good time to call a lawyer because we will look over that for you. We've worked with artists to have their products manufactured or mass produced. We've looked at those agreements. We always find things that need some explanation. Those contracts can be difficult to understand. And oftentimes what happens is you actually have intellectual property from two different parties coming together. So for example, you might have a person who's created something, and then another party who has a system or process that they use to bring these to market. And so this person wants to keep rights to what they've created. This party wants to keep rights to their systems that they've developed. And so there's kind of this sharing agreement that says, well, I've got this and I'm going to let you use it, but you don't get to keep it. So those can be kind of complicated. It's best to talk to a lawyer. Next. What are some red flag keywords to search for in terms and conditions and/or privacy documents before uploading or sharing on social media? And this is Sean. And this is a very difficult question to answer because each of us has different goals. A good friend of mine, I would say that he is very, very privacy conscious. He's very concerned about how people he partners with are going to use his name, likeness, and material. Some people, they're not that worried about it. And so that makes this question difficult. But I did come up with a list of things that I think that you can do a Control F for and search for in a document that I think could lead to some interesting conversations and understandings. First, I am a huge fan of careful scrutiny over indemnification clauses. And so you might want to look for the word indemnify or indemnification. Indemnification is when one party basically is willing to be the shield for another party. And so if someone's lobbing lawsuits or bullets or arrows at someone, then one party's going to take the bullets. And we want to know who's going to indemnify whom. Another word for the same thing might be hold harmless. Oftentimes those are used together, and hold harmless tends to be a little bit more plain English and easy to understand term. So search for that in the same situation. Next, we want to look for perpetual. Perpetual means that you're going to possibly be giving rights to somebody forever and you can't take it back. So that would be a word that you want to just make sure that you understand what you are doing perpetually. Likewise, exclusive. Exclusive or exclusivity is a term that basically means that you're giving somebody a right and you can't give that right to anybody else. So, for example, when you hire a contractor to work for you, sometimes they will actually assign to you or give to you permanent rights, but they may not have that ability, but they might then basically give you exclusive rights. And so they can't transfer ownership, but they can say that no one else but you can use it. So that would be one you want to use carefully. You want to look for remedy or remedies in a contract, because that means if you have an argument or dispute, the remedy section of the contract is going to define what you are allowed to do to fix any problems that you have. And oftentimes you'll see exclusive and remedy near each other because sometimes you might only have one remedy. And it might be a refund or something like that, which if you're using a free service is kind of a not very valuable remedy. You want to look for a choice of law or jurisdiction clause. Choice of law basically means this is the law that is going to govern it. And so if you're in the US, you will typically say the choice of law will be the state where one company, probably the one with more power, is either located or headquartered. Jurisdiction means, when you see that word, that means if there is a place where you can bring a lawsuit, it's going to be in that place. So a lot of companies like to use Texas or certain parts of Texas for their jurisdiction because the courts can be quite business friendly in that area. You might also see California because a lot of technology companies are headquartered there. You also might see Ireland because a lot of companies use Ireland as a home base because of Ireland's tax laws. So just look to know that you're agreeing to laws for this country, and if you have a dispute, you're going to have to go there to deal with it. Then, last for my list is look for long, ugly paragraphs. I draft contracts. I love drafting contracts. I know that sounds so weird, but it's very fun. And if you want to sneak in something that a person might not like, here's how you do it. You go about halfway down the contract, somewhere far enough that you know a person's probably pretty tired of reading contracts, and then you create this big, big, ugly blob of a paragraph. And the first sentence or two is going to look really innocuous and really simple and boring. But in the middle of that contract, you're going to put something that a person might not like if they read it, because you're hoping that they're not going to read it. They're going to skim that paragraph looking at the first sentence to see what they need to do. Here's what you do, and here's actually what I do when I see paragraphs like that. You go to ChatGPT, open it up, create a new chat, and say, tell me what this paragraph means. And then you drop that thing in there, and hopefully it'll bullet point and give you a summary. Now, that is not a substitute for getting legal advice. I think you should get legal advice, but a lot of times contracts will use difficult to understand English. If you see something like that, it probably needs extra scrutiny. All right, so Sean, hopefully that was helpful and answered your question. This is not an exhaustive list, but it's a good start. Another question from Sean: how to tell the difference between necessary sublicensing licensing your IP for product fulfillment versus giving them nearly full ownership versus actual assignment. Okay, so let me first of all just tell you what the word assignment means. When you do an assignment, you're basically stepping out of some kind of right or liability. So for example, if you were in college and you had a lease for an apartment, you were going to leave for a semester, you wanted to let someone else live there and take over the rent, you might have said that you were subletting it or subleasing it. What that means is that you're still the person on the lease, and you're still responsible for everything, but for a little while you're giving your rights to somebody else. But maybe you're not planning on coming back to the apartment and you want out. You don't want to be responsible. You might still use the word subletting when you're talking about it, but the legal word that would be proper here is assignment. And so basically, you have the landlord, you have yourself, the original person responsible for the lease, and then you have a new person who's going to take over for you. When you sublet, you still stay in the chain of command. So the subletter pays you, you pay the landlord, and if anything goes wrong with and the landlord's unhappy, they're going to come to you. In an assignment, you are now no longer in the picture. It is now just you, the landlord, and the new tenant. So assignment, basically you step out and all of your rights and liabilities transfer to somebody else. So if you are assigning something to somebody, you're basically giving up your rights to it. So for example, you might assign your copyright to your work to somebody else. I helped a person who was elderly and they wanted to transfer all of their rights to some copyrightable thing, and so they did so. They assigned their copyright, and so therefore they no longer received royalties or had any say in it. So only do that on purpose. If you are simply sublicing or causing someone to fulfill the work for you, so for example, they might manufacture it or ship it or market it for you, then you want to have a contract that basically limits what they're doing, and it should not have any rights of assignment. And so what you're going to do is you're going to give them limited permission, and so that's what sublicensing is. I've worked with open source software, and one of our next questions is going to be about open source software. But open source software typically has a license, like the very popular Apache license or the GNU GPL license. And so what this does is the people who create the software say, I'm going to give you right to use it, to copy it, to share it. That's how open source software works. You might not want to give them all of the rights. You might just say, I'm going to give you the right to make copies and to distribute those copies. So that would be okay. You might say, I'm going to give you only the right to publicly perform. That's what you need is you need a very clear, well-written, attorney-written agreement that says these parties have certain rights and that's it. Sean, I hope that helped. Let's go on to the next question. No, we're not doing that one. This was a question that came up in one of my client meetings. I didn't ask the client for permission, so I deeply edited their question and threw it on the list for you guys. Should I offer a discount? This is a very, very interesting question. So the answer to it is it kind of depends on your industry. But a few years ago, Groupon was like the biggest thing. Everybody wanted to use Groupon, be on Groupon, copy Groupon. Groupon was kind of the big thing. If you are a restaurant, you know that there's a problem that people are sometimes afraid to take chances and to try something new. You might want someone to overcome that hesitancy and give your restaurant a try. And so offering a one-time discount through Groupon is a good way to do that. And you guys might remember from the Groupon days that the restaurants usually made almost no money on those deals. So you might say, you get $50 worth of dinner for only $25, and then Groupon keeps 20 of the $25. Well, for the restaurant, that's probably a good deal because once a person comes into the door the first time and tries it, they're more likely to come back as long as you do a good job of making them happy. So in that case, a discount is a hugely beneficial thing. You should absolutely consider doing that. However, if you have a product or service that is popular, I would hesitate to offering discounts too often. Now, I'll just tell you that I'm offering a discount on my product right now. I'm offering a discount on wills and trusts. So if you're watching this now, you go to iowabusinesslawyer.com and you click on wills or go to my social account, you're going to see that I've got pricing for discounts. In December, you can do that. I do this because a lot of people are hesitant or afraid to do this important thing. And so sometimes we need to give people a little incentive. It's just like the restaurant situation, a little incentive to try that thing that they're afraid to try. And so how do you choose which products to give a discount on in that case? I'm typically going to give a discount on products that have a higher margin because then if I sacrifice some of my profit, I'm not losing money. If you have a product that costs you $50 and you sell it for $75, first of all, ouch, I would prefer you not do that. But you wouldn't want to give more than a $25 discount because then you would be losing money. Now, sometimes you do that. It's called a loss leader. If you can offer a $50 discount and take a $25 hit, but then that helps you get $100 profit on something else, well, all right, maybe you do that. Grocery stores have been doing this for a while. They'll take their milk and eggs, put it at the back of the store, and sell it at a loss because you got to walk past all of these high profit items first. But I generally would not suggest small businesses do that. Loss leaders are risky. But then we have to ask, do you really want to discount your service? And I would say most of the time, I would say think twice, maybe even think 3 times before you do it. Because what happens is you're sending a signal. One signal is that you're willing to negotiate or come down on price. One signal is maybe that your pricing is a little high and you've got room to negotiate. One signal is that maybe people can haggle with you on these things. So you might not want to do that. There's this general rule of thumb that if you offer cheap products and services, you're going to get cheap customers. And so I don't think that's exactly true, but it's close enough that for conversation purposes, we can go with it. Generally speaking, I want you to price your products so that you make a fair profit, that you get a fair price, that you provide a valuable product or service, and that everyone, including you, including the customer, everyone is happy with the terms of the agreement. But again, for marketing purposes, for giving people an incentive to give you a try, you know what? Yeah, we do it sometimes. Hopefully that was a fun question answer for you. Let's move on to the next one. Did I just do two? No. All right. Eli Mattern. She is actually a lawyer. She and I are connected on LinkedIn, and she asked me a couple questions that were so fun. I was so excited to get these. She asked good questions, so hopefully you get as much enjoyment out of the answer as I do. If a company or startup has more than one product, should they spin them off into different legal entities or keep them under the same umbrella? And so this is actually a very interesting and challenging question. So first of all, I will say this, that there are times where both are the correct answer. So I will say this, that my default behavior when a company has multiple distinct separate products to create kind of a holding company. And so in that case, you've got one group of owners who own numerous assets, each of those assets being a separate company. Each of those companies has the intellectual property for or the brand or the copyrights, whatever, for this other product or service. This can cause complications. And so sometimes that extra complication makes it easier and better for the owners, and sometimes it just makes the owners' lives harder. So let's just talk about how we would think about and decide. Let's just say we've got two products that are closely related that have very similar risk profiles. So for example, let's say a company has one brand, they do cleaning, and they have one brand that does cleaning for homes, and they have another brand that does cleaning for businesses. And so they have two social media accounts, they have two different kinds of customers. Maybe they've got a few customers that do both business and residential cleaning, but for the most part, they've got two different audiences. Maybe they even have two different sales teams. Well, the risk profile is pretty similar, and there's a lot of benefit because they're probably buying their cleaning supplies. Maybe they even use the same people. Their benefits are the same, and so there's very, very little benefit to be gained from splitting them. In the case where maybe the owners say, you know what, we really just want to be residential cleaning company. We don't want to worry too much about commercial anymore, and they're going to sell the commercial business. Well, if the commercial business were a separate legal entity, it would simplify the contracts for divesting that business. But it's really not that hard to say, here are the assets that are included in the sale, and here are the assets that are excluded in the sale. So I wouldn't say that that's a good reason to split the company. I would say that the benefits of being together under one umbrella probably outweigh the disadvantages. Okay, so now let's talk about the situation where you've got different people involved at the ownership level. And so, for example, maybe Jane, she is a owner of XY, and then she is also an owner of CD. And so she could make them one company, but she knows that for CD, she's going to get investors because in order for CD to be successful, she's going to need to raise some money. It makes a lot of sense for CD and XY to be separate companies. And so that's a really, really good reason to do that separately. Another situation is, what if you have very different risk profiles? In that case, I generally like to see those businesses separated from each other. So for numerous reasons, but imagine you've got one company that's very safe, and then you've got one company that's very risky. We would not want to jeopardize the safe business because of a problem with the risky business. And so by separating them out into different companies, then you can segment your risks. And if something blows up at the risky company, then the assets, the functions of the risky company's business are jeopardized, but the safe company is not. So one example that I will often use is a real estate investor who has a bunch of single family houses and an apartment building. And you might say, well, that's kind of the same thing. But we know that apartments tend to have different risks. People who rent an apartment typically are a little bit different than people who rent a single family home. And so you might find that the risk exposure is so different. And then that also brings forward one more example that I wanted to talk about, and that is asset-rich businesses. So let's just use the real estate investor who's got 10 rentals. We typically will split each of those houses out into a separate business, probably owned by one company. But that way, if there's ever a liability, then the assets in any one LLC might be jeopardized, but not all of them. If you have 10 houses in one LLC, and let's just say that you've got $2 million worth of assets in one LLC, and something blows up at one house, now all $2 million worth of assets are at risk. We don't like that. Similarly, let's just say that you've got two tech companies. Each of them have valuable intellectual property, brand names, copyrighted software, copyrighted videos, and things like that. You would not want a problem, for example, a copyright strike on one company to jeopardize the other. So in that case, because you've got significant assets, we would look for ways to split them out. So I don't know. This is kind of a complicated question, but hopefully that gives you some insight into how we think about this. This is a good example of why you should talk to an attorney like me. I do risk management. And so if you have a business or multiple businesses, you've got assets that you want to have looked at, you would call me and I would help you create a plan on how to structure your business holdings so that you have the most freedom and flexibility and the best risk profile for your business. So I would say the short answer, just to summarize it, is that for simple businesses where there's a lot of harmony between the businesses and there is a pretty similar risk profile and the assets are lower, it probably makes sense to combine them. But if you have very dissimilar risk profiles, you have a lot of assets, or you want to have different ownership structures, then separating them is good. Second question by Eli. Are there legal restrictions on advertising your product as a direct competitor to another product? Again, beautiful question. I love it, love it, love it. So what she's talking about here is, let's just say that you are Pepsi and you have said, Pepsi is better than Coke. Is that okay? Can you say that? Or can you say, don't drink Monster, drink Mountain Dew Energy? That's something that some brands would like to do, but maybe they're afraid to do. That's something that some brands would not want to do. They just don't want to mention or make you think of their competitors. But the question is it legally okay? And so I had to do a little research and I found a really great answer on the Federal Trade Commission's policies. And so I don't normally like to quote laws in these AMA videos, But the FTC is an important governmental organization. They do govern how businesses compete with each other. Their policies are generally pretty easy to read. I just had to put a couple little, swap out some words in there. But it says that the policy of the FTC encourages referring to competitors, in other words, mentioning competitors, but it does require clarity and, if necessary, disclosure. And then here's the really important part: to avoid deception of the consumer. And you'll see that the FTC cares about that a lot. They have that as one of the key focuses in a lot of their policies, and we've talked about some of them. But continuing, additionally, the use of truthful comparative advertising should not be restrained. And so the FTC says it is good for you to compare your products to others. And Mr. Newsom, Matt Newsom, the attorney, I think you should also be able to compare your products and services to others. You remember I've said it 100 times. I want your products to be different. It should be very easy for people to look at your brand and say, oh, yeah, that's not like this other company who does the same thing. A young guy came into my office today and said, I'm going to create a copy of this other company. And I thought, why would you do that? Why wouldn't people just use that other company? He says, well, we're going to be able to, to do it just as good. I'm like, well, you can't be just as good. You need to be different in some other way. I'll get off my soapbox now, but trust me, I'm getting back on there again. You need to be different. And so using other brands boldly, I think, is fine. Just remember, the FTC cares about not confusing or deceiving consumers. As soon as you start to get confusing, then the FTC is going to start caring. We saw this in reviews, product reviews. There was a video I did before I was doing AMAs where I said, the FTC is cracking down on consumer reviews with Amazon and some of these other companies. People were doing tricky things, and it was confusing consumers. They were being deceived. The FTC is going to put a halt to that fast. And believe it or not, the FTC is one branch of the federal government that does move pretty quickly. So, short version, please, yes, do compare your products to others. Just do it truthfully. Do it in a non-confusing way. And so the goal here is for consumers to be able to say, oh, I want to choose brand X because it does this differently than brand Y. It is okay if you say better. But if you say it's 10% better, then now if you're crossing into a line where you could be being deceptive, you could be saying something untruthful. So if there is a quantifiable, a numerical, a percentage better or different, then make sure that you can back that up with actual data. All right. Let's move on. Does it cost to shut down my business? Obviously, when this question came up, it was longer, way longer than this one, because this is never an easy question to answer. So I shortened it way down and threw it on the list for you guys. The answer is yes, it does. It does cost, and sometimes it costs dearly. And so imagine this: you're a business owner, you've been trying to bring your dream to market, you're trying to be successful, and it's just not working. And I see this a lot with franchises, especially franchises that are brand new. Restaurants also face this. Franchises, restaurants, and certain other businesses, especially medical businesses, have very high startup costs. And so just before you can open your door, you're going to shell out a lot of money. And if you are new to an area and you're building a brand, it might take 2 or 3 years sometimes for that brand to take off. And so you might have $300,000, $400,000, maybe $1 million invested into this idea. And then if the income is slow to come into the business, your loan payments, your rent payments, your franchise payments, all of those things can be very burdensome. And oftentimes during this process, the owners are not paying themselves. And I think you've heard me say it before, owners need to pay themselves. Don't go too long without paying yourself. But eventually, if the business isn't taking off, then the owner's going to have to throw in the towel. Well, what happens? What are the costs associated with that? If you're a franchise, you're probably going to have to pay a breakup fee for the franchise. If you are financially at your limit, you might have to pay costs related to bankruptcy. Bankruptcy isn't free, and you think, well, I got no money. How can I afford it? It sucks. I'm sorry. You might, and you probably will have costs related to your lease. So if you signed a 3-year lease or a 5-year lease, well, you probably asked the landlord to make some improvements for you. So the landlord might have paid out $40,000 fixing the place up for you. If you end your lease soon, the landlord, first of all, they're going to want to make sure that you're paying the rent until someone new comes in. Second of all, they're going to have to give improvements to that new tenant. So the money that they paid for your improvements, they're not getting back unless you pay it. And that's what they're going to want. And so a lot of times you'll see that when someone launches a franchise or signs a lease, that they have to sign a personal guarantee. That means, well, my business has got no money. You're not going to walk away, because if you have any money or a house or a 401k, well, you're on the hook. So it does cost money to shut down business. Okay, so here's the antidote. If your business is shutting down, ideally you have some assets. Maybe you invented something and you've got a patent. Maybe you've got a trademark or brand name. Maybe you've got some copyrightable material. Maybe you've got equipment or a building, or maybe inventory, things that you can sell. And so this is nice because, for example, let's just use the all too common example of a restaurant that goes under. Well, they've been going at it 2 years. They're out of money. The community is just starting to get into it. Someone can come in and buy you out, take over your lease. Now, maybe you shelled out $300,000 for it, and someone's going to come in and buy it for 60 grand. Ouch, that seems like it hurts. But you know what? If you just close your doors and walk away, you're going to have to pay 40 grand. So now that $60,000 actually feels like 100,000, because you're saving 40 and you're putting 60 in your pocket, and the new person buying you is getting a deal too. So it does cost money to shut down. I am sorry. I wish it weren't true, but it is. So if you're in this situation, yes, I do charge for my services, but I promise I always give people the maximum value, and no one ever leaves my office thinking, man, I wish I wouldn't have paid that. They always are happy. I've got 5-star reviews all over the place. Call me and I will help you make a plan so that we can minimize your loss, maximize your gain, even in this terribly difficult time of having to shut down your business. Dean Stevenson, a serial question asker, asked this question, and I had to edit it down to make it fit on the slide. But is there a resource that shows which services are required to charge sales tax? And why is it that some do and some don't? And I'll just say this, there's two parts of the question. The first one is an easy one. Yes, there is. I'll show it to you in just a second. The answer to the second one is there's no simple answer anymore. But it used to be that if you were buying food, then you did not have to pay tax on it, unless it was prepared food, and then most other products did not. However, nowadays services are usually a mixture of products and services, and so they require you to charge sales tax. There's also consumption tax, which means, if you're using it for your business, you have to pay tax on it. It's so frustrating. The good news is in Iowa and a lot of states, there is a resource. It's the Iowa Sales and Use Tax Guide. And if you go to this page and you scroll down, you'll see it's a long page, but it's a very, very much like an FAQ, where you can click the different categories and expand it. And so that is a resource that you can use to find out what things you might or might not need to charge tax on. But here is the even better answer to that question. You need to talk to an accountant who specializes in taxes in Iowa or whatever state you're in, because these tax laws are changing all the time. I can't keep up with it. I like keeping up with technology laws and Federal Trade Commission and things like that. I read their blogs all the time. Tax laws, it takes a special person who really enjoys reading those blogs, okay? I'll just say it. And guess what? Your accountant is one of those people, hopefully. If they're not, then get a different accountant. Your accountant stays up to date. They do continuing education. They're always staying up to date on what changes, because it changes often. So the answer to your question is you need to ask your tax person for help on which things you need to charge sales tax on. And if you ask them nicely and you pay them a little money, they might even just do it for you. All right. So that's the answer. Another question. We are considering offering a scholarship through our company. What is the process? How is it administered? And then are there other concerns or cautions? This is, as you can tell from the multiple question marks, multiple questions in one. It's definitely a little bit on the complicated side. And so first of all, I want to just say good on you. Yes, you can and you should do this. And you really do have a lot of freedom. I reached out to my friend Drake Vantol, who, if you go back and look at our channel, he's done videos with us in the past. He's an excellent tax person. He said, from a tax perspective, it's probably not going to make much of a difference because your it's going to be treated as a gift. So it's probably not going to help you a lot, but you should tell your tax person what you're doing so that they can help you make a plan. However, you could give tax consequences on the recipient. And so once again, you should talk to your tax person to make sure that you don't cause a burden. This is kind of one of those things that Mr. Beast is famous for. He gets criticized a lot. He'll say, you just won a free jet or a free island, and then the people get this jet or island or fancy car, and now they've got a tax liability. So they've got no money, but they've got a jet, and now they owe $100,000 in taxes. I think that's unfair. Mr. Beast oftentimes offers them cash instead, which is very commonly taken. And then that way, yes, they do have taxes, but they just got $1 million. Okay, now they got to pay $300,000 in taxes. But guess what? They still keep $700,000, way better than where they were before it. So I think it's unfair to criticize him. However, this is an example of what you need to watch out for. You don't want to cause some surprise burden on the recipients. So your tax person can help you with that. As far as what is the process and how it's administered, well, one of the questions that people commonly ask is, can I discriminate on who I offer my scholarship to? And the answer is yes, you can, and yes, you should. So for example, you might say, I want to give a violin scholarship, and so I'm only offering the scholarship to people who play the violin. Okay, well, that's discrimination. You're excluding viola players and even people who are tone deaf. So it is common to have some discriminatory characteristic for scholarships. Now, if you are receiving federal funding for education and other things, then there are certain things you cannot discriminate against. But if you're just a private business, that doesn't really apply to you. However, be careful, because in the court of public opinion, you might lose, even though in the court of law, you might win. So use caution when doing this. And so let's just talk about probably the right way to do this, and that is, to answer the questions, what is the process and how it is administered. A lot of scholarships go unaccepted, and that is, many people want to offer a scholarship and nobody claims it. And okay, sure, maybe you want to get the goodwill of saying, hey, we offer a scholarship, and also the benefit of not actually having to give the scholarship, in which case I take back that good on you statement. My guess is if you want to offer a scholarship, you want someone to actually claim it. Okay, why don't you partner with an organization that offers scholarships to people who would benefit from it and who are in line with who you'd intended? And so, you might find that the school that your kid goes to offers a scholarship, or has a list of scholarships. You could give and contribute to one of those programs. And so that's a great way to do that. There are also nonprofit organizations out there who will help administer a scholarship on your behalf. And so they do charge a fee for that, but it's usually pretty meager, if you're careful, at least. And so that's an option that you can do. So you can delegate it to someone else. But as far as what the process is you just need to make your scholarship available. You need to tell people how to qualify for it. Maybe there's just a club, and you don't want the whole world to know, but you want to tell the club, hey, I'm offering a scholarship. Just tell the people in the club, that here's what they need to do to apply, and then make it clear. Now, I do want to just say that sometimes people will do giveaways, and then they will fall afoul of laws related to lotteries or sweepstakes. And so if you are kind of causing there to be like a element of chance or something like that, then you might fall into these laws. That's probably not going to happen. But if you are promoting your scholarship on social media, I have found that social media businesses tend to have more strict requirements around giveaways than the laws. And the reason why is because those social media companies operate in many places that have different laws. And so by being more strict, it makes it easier for them to comply with laws. even in places that have less strict laws. So if you're going to promote your scholarship and there's kind of a element of chance or a giveaway or a competitive nature to it, you want to be careful not to accidentally get your account on social media banned by falling afoul of their giveaway rules. And so some of those rules can be quite complicated. I found they're actually easy to understand and comply with, but you might be a little baffled at why they're so strict about it. All right, I hope that answers your question about scholarships and giveaways. I hope that you were able to do that and succeed. And that was the last question. So thank you for participating and watching. Even if you're watching the recording, hit the subscribe button or follow me, depending on what platform you're on, so that you see not only future AMAs and live streams, but also we split these up into separate videos and post them out with each question answered separately, and you'll get notified and see the questions you're looking for answered in future posts. Thank you, and remember, Matt Newsom with Surge Business Law. We love helping small businesses like yours, so please get in touch, and we'll help you make sure that everything that we can do to help your business succeed gets done.